Hi. So today I'm here in my home office and the lighting is terrible and you get to see my bulletin board and my messy to-do pile there. But I wanted to do this here because I have my whiteboard and I want to talk today about outlining a reply brief. So you're going to get, so you do this big motion, right? You've got like whatever you're trying to get. Are you trying to get the court to make the other side give you more documents? Are you trying to get the court to, enter judgment in your favor? Whatever you're trying to ask for, you've already asked for. And now you've gotten the opposition from the other side. And now it's your job to write the reply brief. It's like your final chance to persuade the court, right? So in a trial, there's closing arguments, and then there's the other side's closing arguments. And then the plaintiff gets one last chance to be the last thing before the jury goes into the deliberation room. And that's what this reply brief is. So a couple of ground rules. Usually when it comes to the reply brief, you're not allowed to introduce new evidence. So you can't say, oh, here's all these arguments that I wanted to make and all this evidence that I wanted to make before. But now that defendant, the opposing side, has had a chance to, is done with their chance to write an opposition, I'm going to introduce all this new stuff and like sandbag them. You cannot do that. You may bring new evidence if something that they raise in their opposition brings up something that you didn't think about or that didn't seem applicable to you until they raise it as a defense, and now you've got to address it. Then you could bring up more evidence, in which case I think you should usually ask the court, hey, I know I'm bringing up something I hadn't raised before. It's in response to what defendant said, but if you'd like to give them a chance to respond to this new stuff, I'm happy to do that. And like, we'll have a little bit of a delay, but let's make it fair. Let's make it fair for everybody, because then if you win and the defense ever appeals, they don't have that grounds to say that they didn't have the chance to oppose it. Okay. So that's ground rule one. Usually you're limited to like fewer pages in a reply brief. So check your local rules on that. And with that, we'll kind of get started. This week, I thought of this because I'm writing a reply to a motion for terminating sanctions, which means we've asked the court to strike the answer of the defendant. This is a very extreme punishment for the defense, for this opposing counsel or opposing party. And it means the end of their case. And so it's a very extreme thing. It's very difficult to get the court to agree with us. And the courts are very reluctant to do this sort of thing because usually they want cases to be heard on their merits. Same with summary judgment motions. It's really hard to win a summary judgment motion because the court is always going to want to favor letting a jury or letting the case be heard on its merits. But sometimes there are circumstances in which it's permissible to enter like the final blow. It's called terminating sanctions. The case is over. And we think we have a good shot at it in this case. We'll see what happens with the court. But right now I've got to write the reply. So the brief, the motion, was very lengthy. I think that it like took up every single inch of every single page. And that was rough to like even get it down to like the minimum page requirements. The declaration was twice as long as the motion, and the documents offered to the discovery referee in support of our motion was over 1,000 pages. There's just so much evidence here of the defendant being a bad actor and failing to respond to discovery. Okay, so just quickly, I'm going to go through the rules, but then what I really want to talk about is the practical way that you write a reply or outline it. Okay, so in this case, we've got a defendant who missed their deadline to respond to discovery responses. They just missed the deadline, the end. And so when that happens in California, you waive objections. You've waived your right to assert any objections, even if those objections are things like privilege and things like that. So there was a motion to compel, and the court said, hey, you didn't respond timely. Your objections are waived. Provide responses without objections. So the defendant said, okay. So they provided some responses without objections, but they still withheld a bunch of documents. We still know they have privileged documents, but they still have unredacted documents. They still have a bunch of things that we know they have that they haven't produced. And so part of this motion for terminating sanctions is saying, we know they have this stuff because of X, Y, and Z. Here's how we know. We know it from this deposition testimony. We know it from these corporate documents that we can put together that show the relationship between the parties. And we know from their other responses that they have the access to these documents and they're not producing them. And now they're trying to hide behind this corporate shell game of like, well, they're not our documents, they're our sister corporation documents. And we've got to get the court to see that they have access and control over those documents. And they are just literally flipping us off. They're saying, screw you, we're not producing. They never intended to produce the documents. They're never going to produce the documents. Even they've already been specifically ordered to produce the documents and they still haven't done it. And that flaunting of a court order, of a direct court order, is enough for terminating sanctions usually. So we've hedged our bets and we've asked for terminating sanctions, but we've also asked for evidentiary sanctions, which means like we're going to have the court, if we can't get these documents, then you've got to enter an evidentiary ruling in our favor. Basically, like, I'm not going to go into specifics. It's too long to describe, but, and we can do a whole video about that some other time. So now they've opposed and they've said, look, here's all this evidence that proves we do not have access to these documents. Here's everything we've got. We've already given you everything. There's nothing else to give. Screw you. I'm going home. All right. So that's their stance. They said they've given code compliant responses because they did give responses that say, we don't have access to these documents, but we know those responses are a lie because their previous responses actually produced some documents, and some of their other discovery responses say they have those documents or they can get them or whatever. And their litigation person, their claims adjuster within this giant corporation, she admitted that she has access to all these documents. Okay. So now what am I going to do? How do I do the reply? Because their oppositions are very lengthy. Their declarations and their responses or their evidence in support of their oppositions is very long. So how am I going to figure out how to make and crystallize very clearly? I've got to summarize and crystallize all the arguments and the main point of this right now. And I've got to make it hit home for this discovery referee so he can make his final ruling. And in this instance, actually, it's interesting. Usually when you're working with a discovery referee, like the discovery referee will make a recommendation to the court and then the court will enter a ruling. In this case, the parties agreed, whatever the discovery referee goes, it's if the discovery referee makes a ruling, it's as if the court made a ruling. So whatever this discovery referee says goes. He already has been pretty much on our side all along this way. So we'll see what happens. So let's talk about what I'm going to do. I'm going to make a list. Hold on. Where's my marker? Sorry. I went off camera. All right. All right. I'm going to make a list. Okay, so I've got three things. I guess you probably can't read it. The first column over here, I've got agrees. The middle column is disagrees. And the third column is other points. So the first thing I'm going to do is I'm going to go through my motion. I'm going to write down the bullet points, not just the headings from my ruling or my argument, not just the headings, but my actual points, my actual points that I made in support of those headings, right? Okay, so in this case, some of my things that they agree with are that. Sorry, I just lost it. I'm gonna pull up my thing so I can read it, so I can make it clear. All right. One of the documents we asked for in written discovery, it's just a request for production of documents, was the organizational chart of this large corporation. And they have not produced it for who knows why. I don't know why. For some reason, they do not want to produce it. And so they don't. There was a big meet and confer process, and that organizational chart was discussed as part of that meet and confer process. And in that process, the opposing counsel says, why do you need this organizational chart? Because we already agreed that we're going to take out this one affirmative defense we've asserted. And that organizational chart would only go towards proving that that affirmative defense. And so if we don't have that affirmative defense, we shouldn't have to give you this document. You don't need it. And we said, no, we do need it because it goes to these X, Y, and Z, 3 other things that we've asserted. So produce the organizational chart. They did not produce it in their supplemental responses. They said we don't have access to it, or that, in fact, they didn't actually address it at all. They just ignored it completely. They didn't provide the document, and they didn't provide a reason why they didn't provide it. So in their opposition, because they did not say, they made no argument about it. They completely ignored it. They completely ignored our arguments related to the organizational chart. And that means they have not opposed our commentary about it. So our commentary about it is that it's necessary for the asserted causes of actions. It hasn't been produced. It's relevant, and there's no good cause to not provide it. Plus, the trial court has ordered you to produce it, and you didn't produce it, and then you didn't produce it again when asked again, and now this third time you haven't produced it, and so something's going on. You must produce it. So they've agreed essentially that it's relevant, that they've been ordered to produce it, and they haven't produced it. So I'm going to put that in my agree column. So I'm just going to write, I'm going to shortly org chart. Oh, that's an R, arguments. They also agree that the party from whom we're trying to get responses is a subsidiary of this other corporation. In fact, that's like one of their big arguments. They're like, we're just a subsidiary. We're this tiny little corporation. We don't have access to all the documents of our parent company, and we can't possibly be expected to control what's going on at the parent company. So that I'm going to put in that's a fact that I had put in as to prove one of my points. So they agree with it. In fact, they doubled down on it, which means I'm going to make sure to put it here in my agrees column. So, okay. And finally, one of the other things that we agreed upon, or that we argued in our motion, was that despite the fact that this company has an email retention policy of 10 years, that means that emails and documents that are 10 years old or more are deleted. They're just deleted from the system. They're only kept in the system electronically for 10 years. This is a products liability case. And so accidents and injuries related to this product going back over the years are important evidence in proving that they knew that the product was dangerous, right? So we have asked for documents that go back 20 years. They don't have that. But then we've asked them, hey, you've got to put a hold on the documents that we've requested, because if you don't, those are going to get destroyed. Like a couple of the accidents, like one particular one happened in September of 2012. That means right now, documents that happened in 2012 are going to get deleted from the system because it's 2022 right now. They're going to get deleted from the system like right now if they don't put a litigation hold. They have, the evidence of the non-litigation hold is like a deposition testimony of their claims adjuster. And their opposition does not disagree. They say, the only thing they say is that they haven't deleted documents, but that doesn't say that documents are not going to be deleted, or that they've paused, or they put them all to the side to make sure that they're not deleted so the evidence is preserved. So the argument is that if they don't stop this litigation hold, or if they don't put a litigation hold and stop the documents from being deleted, then they're allowing spoliation of evidence. They're allowing evidence to be destroyed. And that's not okay. And The only thing that they say in response to our arguments about that is that documents were not deleted, and they cite to the testimony of the same claims adjuster, who also admits in her deposition that there's no litigation hold. So I'm going to put that in my agrees column as well. All right, now I'm going to put in some disagrees situations. One of the things that they disagree with us on is, of course, the relationship between the parent company and the subsidiary. We've got some documents that show basically that the subsidiary company, they took over this area, and the defense argument is, we're just a tiny subsidiary company. We exist only to facilitate the lease of this property, and we don't have any say over what happens on that property. We're not in charge of that stuff. That responsibility actually is actually the parent corporation's responsibility. But we have a document from our discovery and from public records that says what happened is this little subsidiary company, they're the company with the right to control operations at the right and the obligation based on a permit from the government. They're the one with the rights and obligations to control how everything goes down at this site. Then they, through the lease agreement, they delegate that obligation back up to the parent company. So now the parent company is also the agent, and the subsidiary is also the principal. So this is not just a typical parent-child corporation. This is a parent-child, and then the child gets given responsibility by a governmental entity, and then the child says, hey, I can't handle this, you handle it, parent. And that's a lot different than saying it's just a subsidiary with only like a limited purpose, because that necessarily means that any documents related to falls, injuries, equipment, things like that on the job site, those automatically are in control of the subsidiary company, because they have to answer to the government entity about operations, right? They have to answer to Cal OSHA. They have to answer to the licensing unit. And so they now have, by nature of that license and by nature of their agreement with the parent company to delegate the operations back to them, they now there's more evidence of their control over those documents. So while the parent company is saying the subsidiary doesn't have access to these documents, only we have the documents because we do operations, it's a little more complicated than that. And so that's a part that we disagree on. And so I'm going to put, I'm just putting relationship status. It's complicated. That's a little bit of mom Facebook humor. Okay. So there's a couple other things we disagree on. I'm going to put those in the column. You get the idea. And as you're writing these things in the column, you're going to be starting to figure out really where your arguments need to be. So, and I'm going to probably end up doing headings for each of the agree. I'm going to do one heading that says, I'm going to put in a bucket all the things that defendant agrees with us on. They agree that they haven't produced the org chart, and clearly they're like, see below, they're going to talk about like the relationship between the organizations. That org chart matters, and if it helped them, they would produce it, and they haven't produced it. So we can infer from that it's really important. Okay, so I'm going to make a heading, and that's going to be bullet point 1. Bullet point 2, this entity that we're trying to get discovery from, they're a subsidiary, but they have control. So they agree that they're a subsidiary. They agree, and I'm going to take down the evidence that I've got to show that. And then the litigation hold stuff I'm going to put. So that's going to be like under column 1. That's going to under heading 1 in my opposition. And then on the disagrees side, everything in my disagrees column is going to be a separate heading, because it's really going to have to be fleshed out why we disagree. And I'm going to have to really argue carefully the nuances of those things. And that's where case law comes in. That's where your analysis of the facts comes in, and your questioning of the foundation of their evidence. Because, of course, in support of their opposition, they provided evidence in the form of declarations and a couple documents Is that enough to really support the arguments they're making? I don't know. I don't really think so in this case, but we'll see. And then this other points section is going to be just for miscellaneous, anything else that I want to get in, any like little jabs that I want to put in, any little sarcasm or, nicely worded sarcasm, some stuff like that. That's kind of what I save for the end, a few of those jabs. And then I really bring it home with a nice conclusion. And then, of course, the very last thing you always do is write the introduction. So this is kind of how I do every reply brief I do. That the temptation is always when you're writing an opposition, the temptation is always to just make your headings the same headings as are in the motion, right? And then to like here defend this opposing counsel argues this, and here's my counter argument. Here's their heading, here's my heading, and that's the counter argument. That's a very tempting thing to do, and a lot of times it does work out to do it that way. I usually try to think a little bit bigger, like a little bit more outside the box. I usually like to map it out in columns or in circles of information and try to like draw it out, map it out. There's lots of different ways you can do it, but it's really better if you can kind of make it your own and take control of it. And that's how I feel about a reply brief as well. You get the opposition, and maybe that opposition just mirrors your headings as you went through. Sometimes it doesn't. If they're good writers, it doesn't. And you've got to stop and think critically about how you frame your reply, because you're not trying to re-argue everything you've already argued. You're trying to say and point out why their arguments don't work, why their evidence and their factual assertions are incorrect or not enough to support and lay a foundation for the points that they're trying to make. So it's tempting to, again, to go tit for tat and say this argument is theirs, it's wrong because of this. This argument of theirs is wrong because of this. I think it's even more tempting in a reply to do that than it is in an opposition. But I don't want to do that, because what I want to do is make those points about why the defendant is wrong, why the opposing party is wrong. For me, the opposing party is always the defendant. I'm sorry. I can't undo that bias. I'm really trying, but I can't. I lost my train of thought. Dang it. All right. The thing I'm trying to do, I'm getting it back. The thing I'm trying to do as in a reply is, yes, I want to prove that everything the defendant said is wrong or doesn't have the legal support that they think it does, right? I want to point out all the flaws in their arguments, but I want to, more importantly, I want to clarify what that means for what I'm trying to get. I want to show why that impacts what I'm asking for. And in this case, my argument is going to be, they agree with this list of things. Their disagreements are about corporate structure, but there's no foundation for their arguments because their evidence, the declarations, and the documentation they provided in support of their arguments doesn't lay the foundation for that. It doesn't actually prove what they say it proves. And because they can't prove it, that means that their arguments about why terminating sanctions should not apply aren't persuasive. And if they're not persuasive, then we win. And here's why it's important. And then I want to tie it back in a big circle. And I'm going to bring it back to that organizational chart, because I think the end of my argument is going to be, if that organizational chart helped them, they would have produced it in making the argument that this subsidiary company doesn't have the documents we're asking for. If it helped them make that argument, they would produce it in a second. They haven't produced it. They haven't produced anything other than a Secretary of State document that says like where this subsidiary is incorporated, and a special interrogatory response of theirs that says it's a subsidiary company. That's all they've got for evidence of the corporate structure. And that's not enough, especially based on information we know is true and that they conveniently left out of their arguments, left out of their responses, etc. So that is evidence that they don't want to, and they never intended to respond to the discovery responses. They never intended to comply with the court's order. And if you ordered them again to comply with your order, they would just find another reason to not have to produce these documents. And that's not okay. And that rises to the level of willful failure to respond to comply with court orders. And that is enough for terminating sanctions. That's my argument. That's how I'm going to bring it all around. So you've got to think about, yes, you want to nitpick and you want to poke holes in their arguments, but you, in the end, want to bring it back to the end and tie it up nicely and explain why that matters so much to what you're asking the court for. All right. I talked a lot. I went a little bit longer than I intended to, but this is it. Get yourself a whiteboard, get yourself a piece of paper, make yourself a Venn diagram, do whatever it is that makes your creative juices flow, and think about how to compartmentalize and organize your information in your documents. Sometimes I like to just make a giant list in Word and then copy and paste and move things around until they're in different headings in different places. Sometimes I get a little bit more creative this way too, but you do what works best for you, but try to move things around, try to see what you're working with, and get creative, because those are the really good replies, the ones that really drive home the point and why you should get what you're asking for. Not just that the opposing party is wrong, but that incorrectness is the evidence that you should get what you're asking for. Okay, thank you so much. I will talk to you next week, and I'm not going to even plan what it is I'm going to talk to you about next week. You just don't know. You're just going to have to tune in. If you have questions, or if you're writing something and you want to talk about it on this show, let me know. I would love to do that. We can go through a process. We can go through an actual legal question. We can go through whatever it is that you're struggling with. I would love to be able to talk to you about it. So yeah, send me an email, brooke@ghostbriefing.com, and we could talk about that. And otherwise, just follow here. You can follow us on Instagram at Ghost Briefs, and you can, just say hi. All right. I'll talk to you next week. Bye.